Hello, everybody, and thank you guys so much for joining us here today. I am here with our awesome Powers Law Group attorneys. I am accompanied by attorney Ruby Powers and Cynthia Million. Today, we're going to be discussing on how to successfully respond to RFE, NOIDs, and NOIRs. They'll go a little bit more in detail as to what they are and what they constitute. So I'll let the ladies take it away. But first, let me introduce our esteemed attorneys here. Starting off with attorney Ruby Powers. She has started our firm since November 2009. So our anniversary is coming up, 11 years, whoop whoop. She's been licensed since 2008, and she is also board certified, guys. So you guys know she's coming at you guys with all the hot information. She is also the author of Build and Manage Your Successful Immigration Law Practice Without Losing Your Mind, a really good read. So check it out, share it to your friends, families. They will have a blast reading it. And then secondly, we have our awesome immigration attorney, Cynthia Million, with a fabulous lip color here today. She is the associate attorney here at Powers Law Group, and she's also the vice president of MABA for the Mexican American Bar Association. So check that website out, guys. Really good stuff. And she's also a pro bono attorney for the Montgomery County Immigration Law Clinic. So thank you for all the great stuff you guys do. We are so proud of you. And let's take it away, Attorney Powers.
All right. Well, thanks. I was out last week, but I heard you guys had a great webinar. And today we wanted to talk about something that we've been seeing a lot in our consults, and it's a concern for people. It's requests for evidence, notice of intent to deny, and notice of intent to revoke. And we wanted to give you an idea of what to do when you get one of them, how to approach it, some of the key things you need to know. And we're speaking to those who maybe don't have an attorney, or maybe there's been a potential change in your attorney, and you want to have a second opinion. And this is just something to know, or so that you can be better prepared. So before we get started, we wanted to let you know that USCIS has been generous during this time of COVID on a few things. And one of them is that they are giving people a little bit more time to respond. And so bottom line, for all of these things, most of the ones we're talking about today, requests for evidence, notice of intent to deny, notice of intent to revoke, and all of these listed here, they're giving people an additional 60 calendar days beyond the date of the decision before they take any action. So that's just something to note, and make sure that you calendar that appropriately. This is only for those if issue dates from between March 1st, 2020, which is around the time that USCIS was impacted by COVID, and they went ahead and extended it recently all the way up to January 1, 2021. I think it's been extended twice this year so far. Very likely it could be even more. So it's just important to note that you get a little bit more time, but don't wait to the last minute. Don't be trying to figure out which day it is. When we've invoked this extension, we've more or less just tried maybe an extra week or maybe 2 weeks, just because COVID did hinder our ability to get everything we needed. And so that's just something to note. So we'll go ahead and get started with what is a request for evidence? Attorney Millian.
Sure. So a request for evidence is something that USCIS, the United States Citizenship and Immigration Services, the agency that oversees immigration matters, they can issue this in their discretion to either deny a benefit, or if they see that there's a benefit that you're requesting and it lacks evidence that, based on ineligibility or various factors, then they will issue this. So whenever they issue this request, you have to respond to it, as Attorney Powers was saying, within the allotted time that they've given you. The request for evidence usually specifies the type of evidence that they've required and whether the initial evidence or additional evidence is required, or the basis for the proposed denial, whether or not it's sufficient for the person to obtain that benefit. So the request for evidence can be something simple or it could be something complex. And Attorney Powers will mention a few of those, samples that we've gotten. I don't know if you want to mention them now or after.
Yeah, of course. Yeah, because so we've seen things like requests for evidence for the passport style photos, or it could be as complex as a key element of a case. Now, we're talking from experience from our own cases and from the consults we do. And usually from the consults we do, people either had filed on their own, might have hired somebody who wasn't an immigration attorney to help assist, or maybe had another attorney and they're wanting to get a second opinion. We've seen crazy stuff. I'll just say a couple things. One, sometimes they'll ask for stuff we already gave them. And we're like, why? It just, so that's really annoying. And then some people in the immigration field, we anticipate, a lot of employment-based cases, anticipate requests for evidence. So there's even a theory to withhold some information so that we can have it ready to respond when we get the dreaded request for evidence, which I think is a little crazy, because if we could all be efficient, if we would just do it all right the first time and USCIS didn't give us these. I think sometimes I've seen these with I-751s, the conditional green card, that they'll just do them after a while because they're like, hey, are they still married? Are they still together? And can we get more proof of the relationship? And they want to put off the work to the immigrant. So we've seen all different types of things. We sort of divide things up between, is it the person who filed's fault? Did they forget to put something in? Is it somehow potentially like our firm's fault, like we might have forgotten something, or is it immigration's fault? That's sort of how we look at it, but it really ultimately we have to get it taken care of. And when we think of it like that, it's because we're trying to improve, to make sure that we don't have a similar situation. So normally we don't get a lot of requests for evidence, but we've seen an uptick, I think, in the last year or two, just I think mostly from on USCIS's part, wanting to see more.
So how can you reduce the risks of receiving a request for evidence? I mean, we have our ways of doing it internally. If there's certain eligibility factors or requirements that you have to meet, you make sure that you submit everything to show that you deserve that benefit, right? So you want to make sure that when you file something, whether it's an adjustment of status, or if you're filing a petition for a spouse, or whatever benefit you are seeking, you have to make sure that you've submitted all the evidence to show that you are eligible for it, so that you don't, put yourself at risk of getting a request for evidence. If it's a sponsor, that's sponsoring you financially, you want to make sure that you submit all that financial documentation. If you're doing an adjustment of status here in the US, you have to show proof that you've entered legally, then you need to have that proof. And as Attorney Powers said, anticipate these things. If you don't have a copy of your legal entry, then talk about this ahead of time with your attorney so that we can file the documentation to get proof that you entered legally. When you submit things also to USCIS, you have to ensure that everything is translated properly. So, you don't want to get a request for evidence because something was not properly translated or you didn't include a certificate of translation. So it's best to do everything the first time around and to do it correctly, instead of, having to prolong your case by getting requests for evidence.
That's right. And so what do we do if a person's received a request for evidence? What are sort of the approaches that they should take?
Yeah. So the first thing you want to do is a request for evidence, like Attorney Powers says, could be something so simple, right? Like she said, you're just submitting a passport photo, or it could be something long where it's a 10-page RFE. So the first thing you want to do is you want to make sure that you read it thoroughly, because you don't want to read it, start working on it, and when you think you're ready to file it, you go back and reread it and you're like, oh, I'm not providing X and Y document. So you want to read it from the very beginning, strategize how you're going to respond to each document that they're requesting or each thing that they're alleging. And then there's 3 ways that you can respond. You can either respond, with a full response addressing everything, submitting evidence for everything that they've required. You can provide partial response if there's lack of some evidence, and you can include an affidavit or a statement as to why you can't get that evidence. And the third one is that you can choose to withdraw the petition. So a partial response doesn't necessarily or automatically mean that your petition is going to be rejected. A full response is also not going to guarantee that your petition is going to be approved.
And that's a really good point, because I had a consult, I think, recently, and and they had hired another attorney, and that attorney is no longer available. And I realized that I probably wouldn't have filed it as the way they did, because they didn't have enough evidence for a key element of the case. So that's sort of what you were talking about, Attorney Milian. Bottom line, you want to avoid RFEs. And if you get an RFE, you want it to basically be something crazy that USCIS wants that you're like, why? And you don't want it to be something that you missed and didn't submit, and that it's your bad. And there's a couple things, like she said, that's a key point. If you can't find something, if there's the absence of evidence or absence of collection of ability to collect evidence, you need to explain that, because that can go a long ways. Like, I can't get to somewhere because they're closed because of COVID, or they won't let me because I don't have an ID, or whatever it may be. And so that's something to consider. And there's another thing that's happening, is that USCIS is saying, we don't have to give you an RFE or a notice of intent to deny. We could just deny you. So that was a recent policy this last few months. And so ultimately, that's the reason why you want to avoid any deficiency, because if they think like, in that whole debacle of whether you submit the I-944 or not, we were afraid at some point, like if we didn't submit it initially, would they reject the whole thing? We haven't seen that yet, and there was a lot of litigation, so I think there'll be a little more leniency about that. But another thing to point out is, let's say you get a request for evidence and you don't have the answer. You can't get whatever that thing is. You don't want to just abandon the case. You don't want to just be like, forget about it, because that'll lead to a denial. And denials can trigger bad things. They can sometimes trigger you being put in immigration court. So, and also, if you ever apply again, a lot of the applications ask, have you ever been denied before? And it's better, in general, every situation is different, to have a withdraw it without prejudice means like, don't hold it against me, don't deny me, let's pretend like this didn't happen, sort of. And we've had to do that a few times, then to actually have a denial. There's been so many cases where people filed a marriage-based adjustment, the relationship didn't work out, and they sort of just disappear, don't go to the interviews. And you know what happens? It turned into a denial, which led to a deportation, being put in immigration court, which if they didn't have the address updated, it sent to a deportation order in absentia. So this is where this could be serious. And then we basically talked about some of these key points, which is, the timeliness. I know I will say a lot of people get these like a week and a half after it's dated, and then they come to us and they're really concerned about the deadline, and that's important. But now that we have that extra time with COVID, that gives us a little bit more wiggle room. But and also other things to consider, like changed circumstances, or if you have better evidence. Anything else to mention?
I just want to kind of reiterate that second point, that with the long processing times, just keep in mind that you have to maintain your eligibility, not only when you file, but throughout and even up to the interview. So if anything changes, if you get a divorce or anything happens, if you lose a job or anything like that, just remember that you have to maintain that eligibility at all times. And that's why it's so important to have an attorney, or to get a consult with an attorney, so that you can know that, if a year and a half ago, everything was great at the time of your interview, that everything is still good and in place for you to obtain that benefit.
Yeah, that's a really good point. And we were just talking about that with like naturalization of, if a person files, when they file, they can be eligible. When they get to the interview, they need to be eligible. And if they had some changed circumstances to make them not eligible, that can impact their case. So what is a notice of intent to deny?
A notice of intent to deny is a notice that USCIS will usually issue. And that's when they inform the petitioner and the beneficiary that after evaluating everything, they plan to deny the petition. So typically they give you about 30 days for you to respond. They give you the reasons why they want to deny it, and they give you an opportunity to respond. So it could be something simple, or it could be something complex. And a notice of intent to deny is a little bit more serious than a request for evidence.
And normally, I'd say you would get a request for evidence, you would respond, and then you would get maybe a notice of intent to deny before it goes straight to denial. But I think there might be more. We recently had a case where it went straight, no request for evidence, it was just a notice of intent to deny. And it basically means they're on the verge of denying if we can't make them change their mind. Doesn't mean that it's done, they've already decided. It just means you sort of look at, like, you have to work a little extra harder than a request for evidence because they're sort of set on denial, and you've got to get them out of that mindset. You got to build it up. So what other things how could you reduce the chance of getting NOID?
Yeah, so you can reduce the risk, ensure that there are no misrepresentations in your filings, in your current filings or any previous filings, because all of that will come to light. Make sure that there's not an incomplete application submitted, that you've submitted all the documents to accompany it. Ensure that if the applicant is filing something, that they can overcome a presumption of temporary intent for non-immigrant visa or benefit. If it's a marriage-based adjustment of status, make sure that you submit sufficient proof that there is an actual relationship. And if there isn't, then a statement as to why there isn't any. So if at time of filing, everything's good, and then throughout the process, a person commits a crime or anything like that, then that can be a basis to disqualify them. So it's important for you to consult with an attorney to know if that crime truly is something that will make them now ineligible, or if it's something that can be argued, with case law. I will say that one time we went to an interview. I'm not going to, state all the facts, but it was for an I-130 petition, and someone stated something like jokingly, like, "Of course I married her because I didn't want her to get deported." And that cost us to get a notice of intent to deny. Obviously, there was sufficient proof on the record that it was more.
Did Attorney Milian freeze a little bit? I think she was saying that there was definitely enough information to prove that they met the requirement, but this is something that could happen. And I think another thing to note is that when we're talking about RFEs, NOIDs, and notice of intent to revoke, we're talking about lots of different things, from I-130s to petition for alien relative to naturalization, to I-751s, to I-45s to adjust status. So lots of different things. And these are different ways it could happen. And then what do you do if you receive one? It's a lot like an RF request for evidence. You want to strategize, you want to read it thoroughly. I mean, honestly, a lot of these are templatized, especially for the request for evidence. But the notice of intent to deny are a lot more specific to the matter. But a lot of times they can be weirdly written, and it requires reading it a couple of times. And you want to make sure that you do the best you can of responding. Just don't lose hope. Know that you can overcome it, and just make sure that you respond timely. And then sometimes you might find that it'd be better just to withdraw. Maybe you withdraw and you start all over again. Sometimes you just don't want to, you know that you're not going to win, so you don't want to have that denial, sort of like what we mentioned before. And so those are just things that you want to consider. And this is a little bit more complex. You definitely would need an immigration attorney to help assist you during that time. And so I'm talking more about the notice of intent to revoke. And this one is super, well, hopefully it's super rare for most people. This is really when USCIS had already approved something and then they, for some reason, decide to revoke it. And it's usually because new information comes to light, or some derogatory information, like maybe if it was a marriage petition, and one of the U.S. citizen legal permanent resident spouse writes something and tries to withdraw the case, or there's some provision that was overlooked, because some USCIS makes mistakes. It's just that you know, sometimes it's harder to overcome the revoke, or to be able to apply for the same thing over again later on. The person might not be eligible for the same thing later on. So honestly, in my 12 years of practice, I probably has only seen about a handful of notice of intent to revoke. I don't know how many, but they're not that common. It's basically when somehow USCIS gave an immigrant something and then decided to try to take it back. And the unfortunate thing is, usually this will happen when something might still be pending. We've seen it recently where someone got the I-130 approved, they filed the 45 has been pending, and then now they're going back and trying to notice of intent to revoke the I-130. So otherwise, if you wouldn't have brought attention to the case, or a case wouldn't have been pending, probably it wouldn't have come up. We've also seen, it's not really a revoke situation, but when people apply for naturalization, if there was an issue that they shouldn't have gotten their green card in the first place, what they'll do is just deny the naturalization and then put the person in immigration proceedings. It's a little bit like a notice of intent to revoke in that respect, but it's responded differently. So if you have received one, read it closely, hire an attorney, make sure you know what your deadline is. Figure out what you can do, and if you missed a deadline, consider maybe doing a nunc-pro-tunc. You really need to work quickly and diligently, and these are a little bit more complex. Go to somebody who's seen these and has experience with them, and because this underlying petition, whatever it is usually a key to to a status or some other visa. And now that you've submitted it, and now what? Well, it could take a while. There's not really like a set time. These don't happen that often. And then USCIS doesn't really beholden to a certain amount of time, so to respond back. So unfortunately, you'll be a little bit on pins and needles waiting, but what you probably should think about is, if it was a strong response back to them, then you should feel probably like maybe you're fine and you just wait it out. But and if you're still eligible for that other matter, then you'll just know that you could reapply if you think you're still eligible. If you have no other form of relief at the time, you probably should strategize for backup plans in case they deny it. So that's something to consider. So, you know, concluding thoughts. Attorney Million, this is our time to just, what would our key takeaways? Like, if you didn't listen to anything else, this is pretty much what we want you to, your key takeaways. Well, try to avoid these things, right? If you can. RFEs, NOIDs, and NOIRs, notice of intent to revoke. But sometimes you can't. USCIS, you know, sometimes they're like, oh, this will be fun, let's give these out to people. No, I'm just kidding. So you try to avoid them if you can. Sometimes you can't. The other key point is seek help immediately. So I would say, if you filed on your own, just go get a consult. Find somebody, we can do it. Find somebody you can trust, that you feel has experience. Review it. You might need to show them the prior what you filed. If you have a Freedom of Information Act, show that. Really dig deep, because maybe this shouldn't have been filed in the first place. And so you have to think about those things, but seek competent help. And when you do, also be asking, do you have the bandwidth to help me if I hired you? Because some people might not be able to, some firms might not be ready to respond right away if they have other caseload that's holding them, that they're occupied with. You might have to pay a rush fee or something. Don't delay. I mean, a lot of people get the notice in the mail late. If they weren't getting notices via the text or the USCIS updates online, they might get it in the mail like a week and a half. I think USPS has also been slow too. So that combination, and then they're like, oh my gosh, I only have like 1 more week to respond, 2 more weeks to respond. So just schedule a consult as soon as you get that in the mail, like right away. And then whatever you do, if you're filing on your own or you're going to an attorney, make sure you keep copies and you use tracking. Because like we said, if you do not respond, it can lead to a denial on all the things we showed you today. And you don't just put a stamp on something and think it's going to be okay. Especially now, it's a little bit, I did that for something, not immigration related, but for something, and they got it like 13 days late. They were trying to charge me a late fee and all this. We had to spend all this time calling, negotiating, and and that wasn't an immigration status. So that's why during the filing fee rush, we were FedExing everything because we didn't want to deal with any stress of not receiving things. So document, document, document. And number 5, stay positive. Most of these can be overcome. Most of them. We've had a high success rate in overcoming these things. So any other takeaways, Attorney Milian?
No, I apologize. My internet went out.
Oh, well, that happens. We're in the age of virtual.
Even the most experienced some technical difficulties.
So that's what all she wrote, I guess you could say. Luckily, we have an all-female panel, so that applies. So hopefully you enjoyed our session today. And Dana, any closing thoughts? Anything we need to let them know?
Yeah, so thank you guys for joining us on our webinar today. It was very fun having our attorneys here, and RFEs, NOIDs, and NOIRs. Those are very discouraging things to get in the mail, but do not fret. Get you an experienced attorney and they will handle your case swiftly. And I would recommend Powers Law Group for those services, but I could be biased. But if you guys have any questions or concerns in regards to your case, give us a call at 713-589-2085 or send us an email at contact@rubypowerslaw. We do these Friday webinars weekly at 11 a.m. every Friday, just so we can give our clients and our followers a little update about what's going on and give them some useful information about what's currently going on or the trends that we've been seeing in our consults. Next week, we will be talking about E2s. Yep, so that's an interesting topic. Attorney Ruby, would you like to give them a little scoop about what an E2 is?
So that's more of the investment employment-based category. We're going to do some the treaty trader visas that you could either file inside the country or abroad, and those are not on the list of banned visas or under the proclamation right now. So we can we're helping assist our clients with those. We want to go over a little bit about that, and it's a really good option for people who maybe were laid off and are looking to maybe do an investment to be able to stay in the country. And E2 spouses are allowed to work. That gives more options as well, and can be pretty much renewed indefinitely. So I won't give you any more details about that, but you'll have to watch us next Friday.
Yeah, so tune in for that information on next Friday. I'll be posting the registration link down below. And if you missed our presentation or just hopped on a little late, feel free to check out our YouTube, all of our past webinars, and even here on Facebook, all of our past webinars are here. Share them with your friends, families, if maybe they have a question on any immigration case. And yeah, we had a very good time here with you all. Follow us on our social medias for any updates, and you can subscribe to our newsletter right here down below. I'll also be linking that to keep you updated on any immigration news that are very relevant to today, and maybe some fun tidbits about when our next webinar is, or you might find a funny picture of Ruby with her best boss lady cake.
Yeah, that. I think we should end it with one of the funniest RFEs I've ever gotten. Maybe that's immigration attorney humor, but we once got a request for evidence for an English translation of a British birth certificate, which was in English. So we were like, how do we write this without being insulting? He's in English. We don't need a translation. Anyway, there's not that
stuff like that happens, guys.
I mean, after many years, that's probably the only funny one. But anyway.
Crazy stuff happens. So thank you guys again. It was our pleasure, and we hope to see you on our Powers Hours on Tuesday and on our webinars on Fridays. Thank you again, and you guys all have a great rest of your weekend. Bye.
Bye.
Bye.